And we're live.
Hello, Sean.
Happy Tuesday, Bill.
Likewise.
It is Tuesday.
It is here.
Other parts of the world, it might not be.
Exactly. Somewhere it's Wednesday.
Bill, I got good news for you.
And that is?
Well, it's actually two pieces. Maybe three.
Okay.
Let's start with the basics. One is we've heard a lot about a hot topic lately, California's Assembly Bill 5 or AB-5. And we're going to discuss that today. Two, we have somebody that's way more credible than us joining it.
That's good.
Yeah, I'm pretty excited about that too. Her name's Margarita Ware. She's from the Mayor Law Group. She's a senior counsel there, and they're in the greater San Francisco area.
Excellent.
And three, there might be some Yeezys dropping soon, Bill.
Oh, good. Good. I need new shoes.
You got to upgrade your game.
I'm ready.
Margarita, welcome to the show.
Hi, Sean. Thank you for having me. Happy to be here.
Yeah, thanks very much for joining us. This is a topic we've been hearing a lot about lately, not only for the obvious ramifications of companies in California, which, we'll get into that here in a second, but California is kind of well known for being a testing ground or a proving ground, even if you will, for a lot of these types of laws. So the fact that they're tackling this, what's being tackled in Assembly Bill 5, is quite interesting. So why don't we start with that? What is Assembly Bill 5?
Sure. So there was a California Supreme Court case called Dynamax that came out about 2 years ago now. And what it essentially did was it sort of turned the independent contractor test on its head that was previously set forth in the 1989 Borello case. So what the court in Dynamax did was they established an ABC test for determining whether a worker is an employee or an independent contractor. And the court said that if it's presumed that a worker is an employee, unless the company can prove that the worker is free from the company's control. And the second prong is where that trips a lot of companies up, is that the worker performs work that's outside of the usual course of the company's business. And the third prong of the ABC test is that the worker is customarily engaged in a business outside of the work that they're performing for the company. So this has been the law, or at least the case law, for about 2 years now, and it's been ignored by some. And so I think that's in particular the gig economy companies. So then I think what spurred the California legislature to pass AB-5 is to draw more attention to this and to sort of force compliance with the Dynamax ABC test. So what AB-5 did was it codified and provided some clarification for the ABC test and who is an employee versus who is an independent contractor.
Yeah, so it's pretty clear, I think, that this is trying to target a lot of those gig economy companies, which is probably why it's coming out of California. But let's just walk through, maybe in simple language, if it's all right, those three criteria that a company has to meet to be able to prove whether an employee is, whether somebody is an employee or an independent contractor. It was the person is free from the control or direction of the hiring entity in connection with the performance of their work. What, layman's terms, what's that mean?
Sure, and this is essentially what the old test did. This is what the Borello test looked like. Is the worker free to perform the work whenever is convenient for them, or is the company placing, giving them schedules, and is the worker free to sort of negotiate their rates, or is the company saying we'll pay you X amount to perform this work for us? So it's really the more control the company is exerting over this worker, the chances are they're going to be classified as an employee versus an independent contractor. For example, if, traditionally in the Borello test, if a worker made their own schedule, provided their own equipment, had their own laptop, worked from the home office, there's very little control being exercised on that worker from the company. But the more direction the company gives, the lesser chance you're going to be able to pass this first prong of the ABC test.
Yeah, that makes sense. So traditionally, when you get an offer letter, for example, from a company or a white collar worker, it's going to say, you're expected to complete these duties, probably at this location in normal business hours from whatever, 9 to 5. And for that, we're going to compensate you X, right? That's kind of one of those pretty clear criteria, or if you're hourly, you're expected to show up when you're scheduled, right? Those kind of things where the company's exerting control.
Right. And, versus maybe if it's more, the company just needs help with this discrete project, brings in someone who, has a specializes in whatever it is that project is. The person's free to work on their own schedule on this particular project. Granted, the company's probably going to give them some sort of deadline, but short of that, they don't have an 8 to 5 that they're in the office working on this. It's so that sort of removes some of the control that the company has over them, and they're really at their discretion to complete this project. I think that falls more into the independent contractor scenario versus an employee that you described with the offer letter, the 9 to 5, the hourly rate that you were describing.
That makes sense. And so what about the second criteria, which is that the person performs work that is outside the usual course of the hiring entity's business? What does that mean?
So this is the one that I think is going to trip a lot of people up, because typically a company, if you're wanting some help, presumably the reason you don't need an employee is maybe you don't have enough work to justify bringing an employee on, but you are swamped and need some help. And typically you're going to hire someone who can help you with whatever your usual course of business is. So for example, if you operate a bakery and you bring in someone to decorate cakes, that's in your usual course of business, right? Versus if the same bakery has a plumbing issue, you bring in someone to fix that plumbing issue. Plumbing's not your usual course of business. So that would be an independent contractor under this second prong of this test.
That one's pretty clear. Why do you think this is going to be the one that trips most up? Because
I feel like the reason someone would bring in an independent contractor is is typically because they do need some help, and it's good. And their help that they need is going to be in carrying out their business. So, for example, this is what Uber and Lyft are fighting over right now. They're arguing that their use of these drivers, they're not a transportation company. That's not their usual course of business. They're actually a technology company putting these drivers and connecting these drivers with people who are in need of transportation. So I think this is where the most litigation is going to be centered around, is what usual course of business means.
Yeah, this is going to be where like the haughty view of tech companies and how we think about ourselves meets with reality of what we probably really are as everybody else would describe us, right?
Right. The world doesn't look at Uber and say, they do technology. The world looks at Uber and says, they get me from point A to point B.
I order a car when I get somewhere and they take me from there to there. Yeah, for sure. But most tech companies would say this, right? Like Twitter would say they're not in the communications. I don't know that they would say this. Twitter would say they're not in communications. They would say that they're in the movement of progressive ideas, right? It's like, how lofty can we talk about ourselves?
Exactly. So this is it's really going to take some court opinions and decisions to really narrow down what those few words mean.
Right.
And I want to get into that because there's a good example of that recently. Well, let's just cover that last one real quick, which is the final criteria. The person is customarily engaged in an independent established trade, occupation, or business.
So, for example, that the company is not that person's only client. So you're performing work for you're opening yourself up open for business for other companies and contractors, or I'm sorry, not contractors, other companies as well to hire you.
So this is where, like, if you're an independent marketing consultant that works for a bunch of different companies, that you fall under that.
Yes, that puts you in a much better position to pass that C prong. If you're this marketing professional with multiple clients and not just the one company who is having to do this test.
Got it.
Isn't there also something in there like that you portray yourself to the outer world as an independent contractor providing that kind of service?
Right. So that, yes. So that I think that language comes out of the exemption, the many exemptions under AB-5. But yes, holding yourself out to be an independent and separate business certainly helps you get past this C prong of this test.
And so let's dive into that part for a minute. I'll just take a quick, a quick tangent here. All those exemptions, that's kind of the interesting area that I think at least in my opinion, is going to be where a lot of this stuff still plays out, right? Because you hear stories coming out of like musicians, right, that a venue would hire just to play for Thursday nights from 9 to 12 or whatever, that they're now having to figure out ways around this, and or the venues are not hiring them. What's this like fact from fiction here with those kind of careers?
I think that's right. And specifically with musicians, I know that there was talk about including them as as one of the exemptions, but they weren't able to come to terms with what that language would look like. So it hasn't passed yet, but I think that is something that's in the works that they will be exempted out at some point if they can agree to whatever that exemption would look like with the legislature. But short of that, I think in order for a venue to bring an act in and not have them be considered employees, again, they're going to have to convince a court that perhaps they serve food and drinks as well. So it's their usual course of business to provide these food and drink services, and the band that's playing is sort of an incidental part of their business. That's just something that hasn't been determined, and we'll see how that plays out. But I do think for musicians, they will eventually get exempt.
So each one of these flavors basically just has to take its time to run through the courts and or get updated in the bill.
I think that's right, yes.
But there were a bunch of exemptions built into it, weren't there? Like
there were
doctors, lawyers, always lawyers.
Yeah, of course, lawyers. The people with the powerful lobbying groups, I suppose, were able to exempt themselves from this. But so mainly professionals, so doctors, lawyers, architects. There are several other ones, kind of these niche industries like hairstylists, HR professionals. There are some marketing professionals that are exempt. Some freelance writers and there is an exemption for freelance writers and photographers, but they're limited to submitting with a cap. So 35, with it, if they provide one periodical, 35, stories or photographs, then they can fall within this exemption. But I know that's been causing some issues for them as well, because their biggest clients typically ask for more than that. So there's been some fallout for them. But so yes, mainly professionals and just some of these niche industries that work their way into these exemptions.
Yeah, I think when it first started to roll out, you saw, I forget what firm it was. It was a New York-based firm that let go of a bunch of their freelance writers
That's right.
that were based in California.
Yeah, Vox Media, I believe.
Yes, Vox. Thank you.
Yep. Yeah. So an intended consequence, I suppose, where instead of making sure they comply, the freelancers comply with that 35 story cap, they just stopped working for California freelancers altogether. So it's an unfortunate byproduct of this law.
And the only other thing that I would think about when thinking of this, there's a million other things, but one of the bigger ones is like when somebody retires, right? And they still want to do a little consulting on the side within their domain expertise. How does the law account for that, if at all, right now?
It doesn't. So it's all going to come down to what those companies that they provide those services for, how they end up treating these employees, or I guess independent contractors right now. So I think one of the fears for the folks in the situation that you described, they like the independence, they like being able to create their own schedule. But if the company is forced to hire them on as employees, do they lose that flexibility, or is the company going to take advantage of them being employees and putting them on strict schedules if they're going to have to pay them for the entire time they're providing those services? So it has yet to be determined, but I hear you, and I understand those people's concerns.
Yeah, I mean, I guess overall, does this start to go after some of the benefits of the gig economy, there are a lot of downsides, and I understand the purpose that this is trying to tackle.
Hmm.
But you have, like, I remember one of my Uber drivers was a retiree that he's like, you know what, gets me out of the house. I go out in the morning, I drive around a little bit, I make some money, and then I'm back home in the middle of the day. I pick my grandkids up from school, right? Like, that was cool to him. He was totally fine with that. And now I'm going to guess this probably eats into his ability to do that.
I suspect that's right. I know there's been a lot of challenges to this bill, and there have been some vocal folks in that situation and they're backing some proposed new legislation to combat the downside of AB-5. So I know there's some bills that they're trying to push onto the ballot in November. So it's really just, everything's really in flux right now. So it's kind of a wait and see game.
Yeah, California's kind of notorious for that, right? You can get any proposition
Right.
as long as you get enough signatures.
Exactly. That's, and I think they do have enough to make it on the ballot, or at least one of the ones I've seen. I know there have been multiple proposed legislation, but I expect to see at least one of them.
That'll be interesting. We'll have to do an update for that then.
Maybe it would be helpful to talk about what the sort of costs or downsides are for the employers that are presumably forced to move people from independent contractor to employee. And I'll add a little twist, is there a difference if you become an Uber driver full-time versus Uber driver part-time in that scenario?
Sure. For downsides for the employer is, there are going to be the increased costs because there's going to be it's about 30% for payroll taxes, and they're going to have to keep better records because now they're subject to the wage and hour laws. So if they work overtime, they'd be entitled to overtime pay. If then employers are supposed to provide meal and rest periods, so tracking if those were taken, and if not, that's another hour of pay that they would be entitled to. So things like that, definitely more record keeping. And if someone's an employee, they're entitled to, there's the California sick leave law, so then they'd be entitled to that as well. And then they're covered by the various employment laws where their pay stubs are going to have certain things on there that I'm sure an independent contractor wouldn't have now. They would be covered under the anti-discrimination and harassment laws, where independent contractors currently aren't. So, it's, in addition to the increased costs, there's kind of administrative issues for the employer to track, to make sure that they're in compliance with all these various labor laws.
Got it.
And do you see, I'm sure some of the clients that you work with are being, to some extent, some of them being proactive about this. How do you see them starting to, process this or even take action on it?
Sure. So it's funny now. We were ringing the alarm bells last year when this got signed, but I think people are really paying attention now, and it's accountants have actually been the ones to push their clients to employment attorneys, because now they're doing their taxes and seeing their use of independent contractors, and really recommending that these folks talk to employment attorneys to make sure their use is compliant with AB-5. But for our clients, we really encourage them to take a look at their use of independent contractors, and if they can pass this ABC test under AB-5, and if they fall into one of the exemptions, then we review their independent contractor agreements to make sure they're in line with what those exemptions require. And remember, just because you're in an exemption doesn't mean you're in the clear. You still have to pass the less rigorous Borello test to be classified as an independent contractor. So we kind of look at all these things, make sure their independent contractors are accurately reflecting, the requirements of the Borello test and those exemptions under AB-5. And there are also clients who say, look, I hear you, I hear the risks, but we've done the cost benefit analysis, and we're just going to roll the dice and take a chance that we don't get caught. And that's their prerogative, I suppose. I would never encourage our clients to willfully not comply. But, at the end of the day, some decide to make that business decision. And I just warn them that that could be a very expensive risk that they're taking, because if they're assessed, if they're found to have misclassified some workers, not only are you responsible for the back payroll taxes that you haven't been paying, but there's penalties and interest on top of that. And then if you've been misclassifying someone as an independent contractor and not complying with the various employment laws, like wage and hour, there's all these penalties that come into play with your non-compliance with those as well.
Penalties in addition to the back pay or whatever.
Correct. Yes.
Isn't the Dynamics, the thing that triggered AB-5, isn't that retroactive? So what does that mean?
So that one is still a bit gray. So there has been fights about the retroactive application, but I will say for non-compliance with statutory laws, there is a 3-year look back period for that. So if you have been misclassifying, haven't been paying overtime, or have been providing meal and rest periods, there's a 3-year look back period for those.
And so one of the other reasons I think this got a lot of press recently, to the point that you were making accountants are for sure probably helping to surface some of this, was I think it was just last week, Instacart kind of had a ruling against them. Can you tell us a little bit about that?
Sure. So the court, so there was a lawsuit the city of San Diego brought a lawsuit against Instacart about their non-compliance. It was for unfair business practices because of their misclassification, according to the city, misclassification of these workers as independent contractors rather than employees. And the court did issue a ruling that, yes, Instacart is probably not complying with AB-5, or probably been misclassifying these workers. But the court stayed enforcement of that. I think partly because enforcing it would kind of require the court to oversee the changes in their operations, and the court just wasn't willing to do that at this point, particularly with the other lawsuits that are happening all at the same time. I think, in knowing that Instacart was going to be appealing this, so the court signaled that Instacart is misclassifying, but hasn't taken any action to do anything about it yet.
But that was kind of the first shot across the bow, I guess, in terms of a ruling for this.
It was. And Lyft, they also filed a lawsuit challenging the constitutionality of AB-5. And the court signaled that they were probably, because they were asking the court for protection from it. And the court said, you're probably not going to prevail. So that was, these challenges to the laws, or I guess in Instacart's case, they're them defending against the lawsuit. They've not been successful yet. But interestingly, one challenge has been successful so far, and that's been truckers. They've filed a lawsuit to be prevented from having to comply with AB-5. They were saying that there's a federal law governing them that preempts AB-5, and that federal court did side with the truckers there. So there's these multiple lawsuits all happening at the same time. And so I think going back to Instacart, I think they're waiting to see what the higher court says. So then there'll be kind of a uniform, I guess, standard or ruling that would apply to these various challenges that are popping up.
So what we've talked about here, I guess, is most of what we talked about, although we did give some examples otherwise, but most of what we talked about is companies that are based in California. What about those that are based outside of the state but have contractors there?
Right. So generally the rule is the state that you're providing services in, those would be the state's laws that apply. So if you're a company outside of California, but you employ contractors in California, you would be subject to AB-5 because your workers are located here. Conversely, if there's a California company who's employing contractors out of state, that those states' laws would apply, not necessarily AB-5.
So Uber has drivers in New York that might not apply to those contractors unless New York would enact that same law or similar.
That's right. Yes.
And are there any of those leakage, like people that cross the border from Arizona or Nevada into California driving for Uber?
Yeah, that does happen quite a bit up near Tahoe. But so yeah, I think if the drivers spend enough time in California, the best thing to do would be to treat them as California employees.
And this is a little bit of a non sequitur, but is there any burden on the employee or, in Uber's case, the driver or the contractor to challenge their status as a contractor? If, like, Sean gave the example a little bit ago about, a retiree who's driving, basically to keep himself busy and make a little pocket change, is he required to challenge and say, no, I should be treated as an employee?
I'm sorry, are you asking if
he's happy with the status quo, can he just keep going on his own?
There's no opt-out of AB-5, and so they're unfortunately stuck with it, even if they do not agree with it.
Maybe my question is more along the lines of, we know that Uber and Lyft and maybe Instacart and Postmates are all challenging this, so they're not reclassifying.
Mm-hmm.
So I guess my question is, if you drive for Uber in California and they don't reclassify you, are you as a driver at risk?
Oh, I see. No, I don't believe you would be. I mean, you can only do what that company's you kind of can go along with what who you're providing services for.
And then you just, sort of stand a potential windfall later on down the road if it turns out that the law sticks and is enforced, presumably in your favor.
That's right. I mean, I suppose if, if you're having issues now and you think you're being misclassified, then, you can alert the state agencies, but in the case of Uber, they're already alerted.
They know.
So they're already looking into it. So, but if it's for another company who may not be as high profile and on the radar, then the recourse for an employee who feels like they've been misclassified is to file a claim with the state agency, and they would take that up with the company. And I know Governor Newsom did pledge, I believe it was a certain amount of money for enforcement of AB-5. So I think these state agencies do have some backing and additional backing to pursue these claims.
I'm curious, if you were to read the tea leaves of what happens in the next year or whatever future makes sense for this, where do you think this goes?
It's a tough question. I think these challenges will continue to pop up, and I think courts like the Instacart court will continue to punt, expecting appeals. And I think it's just going to take the higher court, the Court of Appeal, the Supreme Court, to take this up and kind of come up with a definitive. It's also going to be industry specific, right? So because there's very specific challenges to the wording. Uber and Lyft, they're challenging how they are being treated, and they're not advocating for the rest of the gig economy. So I think it's going to kind of be a industry by industry specific challenge to the usual course of business or whatever part of the law that they are really taking the legislature to task for. So, and we'll see what I am very curious to see how that ballot initiative in November shakes out, because there's been very loud supporters and very loud detractors from this law. So I'm just not sure where the majority where they are on this. I guess my best guess was there's probably going to be enough support for the workers for whatever ballot initiative to It just depends on what it is. I know one of the things that they're propose, it's kind of a compromise. So one of the ballot initiatives that the gig economy employers are suggesting is, setting a minimum bar to the wages. So, they'd be $30 an hour, I think I heard at some point. And then, there'd be some benefits. So it's a compromise somewhere in between AB-5 and independent contractors, full-on employees. So I think it'll also largely be dependent on how reasonable and how well taken those compromises are in that ballot initiative. But it seems like people are pushing for something in the middle. There are because I think another unintended consequence of the bill is the costs are going to be passed on to the consumers. So right. I don't think people are going to be ecstatic about how the bill currently reads, if that's going to be the case.
Yeah, that gets into a whole business model thing, right? Like you can tell just by Uber's pricing right now, for example, that they're going for profitability, or at least maybe not losing a ton of cash. Just by, you can see that they're raising their prices and going after that, and basically what they're promising the street as well. This could, at least in certain areas, especially California, raise that even more to the point where it probably might start to affect their business model, I would suspect.
I think it is. I think their business model is really dependent on not having these labor and employment costs. So if in the event that those kick in, then yeah, I 100% agree with you that it's going to get passed on to the consumers. And, we take Ubers and Lyfts and get into cars as strangers because it's so much cheaper and it's so convenient. But if the prices are going to be in line with a cab, I think you would think twice about which car you jump into. The taxis are licensed, there's more safety regulations in place. So yeah, I mean, I think it's definitely a threat to their profitability and business model.
Have you heard any rumblings elsewhere in the country about adopting similar kinds of rules?
Yes, I think New York is closely watching California, and I've heard that they're putting together a similar legislation, and I believe I want to say Oregon, and there's like a few other states that are putting together their own set of independent contractor ABC tests, similar to Dynamax and AB-5. So yeah, I expect those to come soon.
And I'm sure they'll all be slightly different to just make everyone's lives miserable.
Yes, to keep employment attorneys employed.
Exactly.
So is there anything else, A, thanks for your time today, but B, is there anything else that we should know, that we might not have covered during this conversation?
I think it can seem very daunting for especially smaller employers. But there are options. There's additional options too. You don't have to have a 40-hour full-time employee if you don't have the need for it. You can craft an agreement with, say you've been using someone as an independent contractor and you probably don't pass this ABC test. What do? You can offer them a position as an hourly employee, and you hire them when you need them. So if for some of these employers who just don't have the full-time need. So, but the difference being you really have to keep records, and that person is going to have to keep records, and they might not be used to doing that as an independent contractor. But I want employers to know that there are options out there. If you've got people who you like working with, but are concerned that they don't pass this independent contractor test. So it's not, once you kind of wrap your head around, meal and rest breaks, overtime, that sort of thing, it's really not quite as daunting as it seems.
Yeah, that's good advice. So we appreciate it. If you're interested, Margarita, can we leave your contact information in the notes to this episode if anybody's interested in following up with you or chatting more about this?
Sure, absolutely.
All right, well, great. Thank you very much. We really appreciate you walking us through this and explaining it at my level, which isn't really high, and helping us better understand this. It's as you know, I'm sure it's a very confusing topic right now that's evolving. So it's tough to keep up with if you're not
right.
into
The
this every
evolving
day.
makes it harder.
Everything makes it harder, Bill.
Absolutely. But yeah, I'm happy to help if anyone does have additional questions about this.
All right, appreciate that, and thanks again for everything. This was great. Really should be helpful to everybody listening. So, reach out to Marguerite if you have any additional questions. If you're curious about the new Yeezys dropping, Bill's all over that. Send him an email. And yeah, thanks everybody. We'll catch you next time.
Thanks.
All right, thank you, Sean. Thank you, Bill.